Tim Blankenship here, Divorce661 Daily Perspective, episode 63. It's our daily podcast. My name is Tim Blankenship, legal document assistant or paralegal, if you will, specializing in amicable divorce throughout California. I always like to start off by thanking all current and past clients and future clients for trust in using my service over the last 12 years. I go over questions that come up in consultations, issues clients have, reasons they hire me, problems they're having with rejected judgments, and so forth. There's going to be a lot we're going to cover today. We're going to discuss, again, over consultations. We're going to talk about decisions you have to make regarding support, spouse support decisions, how we consolidate your divorce process and do it in about a month versus 6 months. We're going to talk about children born before the marriage and what has to happen there. Talk about child support orders and some changes that are to the child support 342 order, as well as the 343 spousal support order. So I got a lot, maybe 10 more things other than that for you. I always like to start off with the stats, and I give you the stats not to impress you, but just to show you that for the last 12 years, we have grown and we do cases, we do handle amicable cases all over California. 40 cases so far this month, 167 total divorce cases so far for the year. Filed 2 new cases today, one in Riverside. It was a summary dissolution, and then a new case for LA County. Had a couple cases approved today. One LA County, we from start to finish, from when they hired us to where we had it approved by the court, was 45 days. That was a new case. Keep in mind, I always get asked after when people watch these videos, do the 6 months still apply? And yes, it does. But they are totally done, signed by the judge. They're just waiting for their final date to pass, which I think was sometime in September. We also had a Sacramento divorce case approved. Got that in the mail today, and it was about a 30-day approval, which is great because some courts are taking several months, and Sacramento, they used to be in that several month category. Now we've had probably 3 this month approved, and they're in about 30-ish days, which is great. I submitted 3 judgment packages to court for approval. 2 were in LA County, which are always e-filed. 1 for San Diego County. As usual, we have everything finalized usually within a week or so, well within the 30-day window. So like in both or all 3 of these cases, we had previously finalized all their paperwork 2 or 3 weeks ago, and we're just waiting for that 31st day to be able to submit for approval. And you're asking why the 31 days? Because we treat our cases as default with written agreement, it's still considered a default case as far as the court's concerned. So before we can submit the request to enter default form, the 31 days have to pass. So that's why we have to wait. If you want a pro tip, if you don't want to wait the 31 days, and we've had people do that, they just don't want to, it's still not going to change when your final divorce date is, but we can submit it sooner, and you can do that by filing the response. And we've done that before, where we file a petition, day 1, get it filed, get a case number, right behind it, file the response. Now there's no clock to wait for the 31 days because the response has been filed, and you can file the judgment right behind that. We had that, I forget what county, maybe it was Contra Costa this month. We did that. They just wanted to get it done. And we did all that in the same day, filed the petition, filed the response, did their settlement agreement. They signed it. If it had been an e-file county, we could have probably submitted the judgment the same day, but they had to mail in their signed wet signatures with the notary and all that. But we got able to submit that probably 3 weeks sooner than we would if we were not doing the response. So, all right, what else we got? So we talked about the judgment submitted, settlement agreements drafted, did a bunch today, LA County, several, Riverside. When I say settlement agreements, after we file and people get me their terms, I have to draft their settlement agreement. First we file, do the initial summons, petition, case cover sheet, or whatever local form a county might have. And then once we get the case filed, we can start working on all the final documents, judgment package, settlement agreement, basically your terms that you guys agree to. Today is Wednesday, April 24th, and we do this daily podcast. Wednesdays is interesting because I usually block out my calendar so that you cannot schedule consultations on that particular day. I do need one day during the week, and that's a schedule at midday where I block out my calendar so I can not be distracted by consultations, because they do take my time, obviously, and resources, but you can schedule all around that Monday, Tuesday, Thursday, Friday. But I do need one day to process the judgments, as you can see. I have to prepare settlement agreements. I'm still returning calls and talking with clients, but that's kind of the day I spend doing all the processing, because if you're looking who my processor is, it's the same person that's talking right now. Okay, so spousal support decisions. I want to go over this. So when people will tell me, Tim, we want to have spouse support, and it comes in 2 ways. One, we don't know how much or how long or anything like that. The other people, at least they know an amount. Like Tim, we agreed to $500 or $1,000 a month in spouse support, something like that. The other decisions that have to be made is, okay, so how much? We talked about that. I can always run numbers for you through the support calculation. We have access to that based on incomes, we can run the numbers, see what that looks like. I tell folks, don't use that as an absolute. You can, but you can also look at maybe one spouse is getting more debts or more assets or something like that. And so maybe other than what the calculation shows, there's something else you guys want to agree to more or less, but you can use the number, and many clients do. So you got how much, how long is it going to be paid? So we're talking about duration, start date. When do you want it to start? When do you want spousal support to start? Do you want it to start when one of you move out? Do you want it to start when the judgment is entered by the court? Do you want it to start when you're completely divorced and you're no longer single, that entry of judgment date? So there's different timeframes there that you can use. You can use periods in time, like when the house is sold and you guys move out of the house, that's when support starts. So you have some options when it comes to that. So how long, start dates, end dates, obviously. And then when should it be paid on? The 1st, the 15th, etc. And then how will it be paid? It'll be a check. It'll be a bank transfer, a Zelle payment, or you can go old school and do a income withholding order, and it can be taken right out of your check. I think I've only had one person actually want that in thousands of cases in 12 years. So that's not very popular option, but it is an option. I want to talk to you about the 6-month process and how we handle your divorce differently than if you were to do this on your own, or even if you were to do it through an attorney. Because we're handling amicable divorce cases, we're able to consolidate the divorce process into a few weeks, sometimes a few days, sometimes just a week, versus the 6 months when dealing with the court. So I'm going to give you, for instance, I'm going to read my notes here. For instance, we had a new case filed this week. The parties already had an agreement, and once we received the filed petition, we were able to finalize the remainder of their paperwork to include the settlement agreement and judgment package, have them sign, and now we just wait the 31 days. So I kind of foreshadowed that a bit in the beginning, talking about how the cases we got approved or that we submitted for approval this week were cases that we had finalized. They had signed the settlement agreement, notarized, did all the procedural documentation, and we were just waiting until that date. So there's no reason to drag that out when you hire me. And if you have an agreement, we like to get it knocked out as quickly as possible. Sometimes we get a little busy, so it might not be a week, it might be 2 weeks, but still we're well within the time frame to where we can even submit your judgment for review and approval. One of the cases today, San Diego case, while we can have everything e-signed and e-notarized, which is nice, we cannot e-file any of the documents past the petition and summons. So, but it's easier for clients and myself because it's e-signed, e-notarized, that it's easier for me to print out and make the copies, and you won't have to go in and sign, print your paperwork, sign it, walk into a notary, then mail it all to me, all just shoveled and shuffled up, and signatures missing and so forth. So it just makes for an easier process with San Diego, at least. All right, next, 5 cases this week so far. It's only Wednesday that we've started that had children born before the marriage. And it's not an issue to have children born before the marriage. Many people do. In fact, 5 of our clients this week already. The thing is, I have to, when I'm doing the judgment, whether you started with us from scratch or you started your own paperwork, when I'm looking through your petition and I'm preparing your judgment and your settlement agreement, I have to check when there's minor children what the dates of birth are of the children. And if the date precedes the marriage, as it did in these 5 cases, we have to attach a declaration of paternity to that. Now, the declaration of paternity is a form you would have received in the hospital. It's not the birth certificate. It's declaration of paternity saying who the parents are. So most of you will not have that. I think I've had one client in 12 years actually have the declaration of paternity from the hospital, and which we need to attach to the FL 170, and you have to mark that the declaration of paternity is attached. So it's, if you submit your judgment with children born before the marriage and do not check the box on the 170 and 180 that there's children born before the marriage and parentage is established, and attach the FL 170 and attach the declaration of paternity to the 170, your judgment will get rejected. So what happens in all these cases, because people don't have the declaration of paternity, I found one online, and it's not something you can just print, but I copied the language for the most part, came up and drafted it into a declaration with all the appropriate language. And I have my own document that the courts have accepted for years that I created to handle that issue. So not an issue having children before marriage. However, there is different paperwork you have to submit that's not going to be a regular court form, and you're going to have problems getting your judgment through the court. All right, next subject. Should you request to restore your maiden name during divorce? I think you should. The key word being request. I'm not saying you need to go out and change your maiden name, but I'm saying request it in the judgment. And here's why. Let me back up. A lot of people don't want to do it because, let's say, mom wants to keep the same last name as their kids while they're in school. Great. Makes sense. But let's still request the restoration of your maiden name in the judgment. So maybe in 10 years, when your kids turn 18, you no longer need to have the same last name of them for, school and whatever. Then you have your court order that says you can restore your maiden name, and you don't have to go back to court, try and find your case number, pay more fees, file a ex parte motion to go to court to get the name restored. You already have that. But what if you never end up using it? That's fine. Just because you request it doesn't mean you need to go to court. Doesn't mean you need to actually ever do it. So you get the order as part of your judgment that says that the court orders your name restored to Smith. And if your name is Johnson, you never have to change it back to Smith, but you have that option down the road. That's why I always say, doesn't hurt to do it. Doesn't mean you have to do it, but you have it if you want to do it later. Hope that made sense. Okay, now we're going to talk about some changes to the child support order attachment. We're talking about the FL 342. We have changed this into kind of a standard protocol now. There was only one or two courts that were requesting that these mandatory fields be checked, and a lot of the courts weren't. So just how we handle it here at Divorce 661 is now we check it off in every case, because sometimes a new judge will come in or a different clerk and they'll flag it and reject the judgment. So to avoid that happening, I'm going to share my screen here real quick and show you what I'm talking about. Let's see, share. Okay, so here is the 342 page 2. And so on the three, let me just bring up the first page. So you're talking about the child support order attachment to the 180, to the judgment package, right? So if you're going to have child support, you're going to have your child support numbers in here. I don't know if you can see my cursor. Maybe it's here. You find your child support numbers here. And then they have mandatory fields. You have your mandatory additional child support, mandatory additional child support. So what we are normally doing now, before we used to leave this blank, and then certain counties like Orange County would flag this and say, hey, these sections, they say mandatory, therefore they're mandatory. That was probably like 5-6 years ago. So since then, we've started doing that, and we start seeing some other courts require it as well. So we're just going to do it across the board so we don't have issues with our clients' judgment papers getting approved by the court. So what we're going to do here is you're going to mark the mandatory box, and then you're going to mark box A and mark B, box B. And in 99% of our cases, we're just saying 50-50. So 50% to petitioner, 50% to respondent. Same for mandatory additional child support, 50% to petitioner, 50% to respondent. Now, today I drafted a settlement agreement for clients who dad was going to have full legal and physical custody. And so in that case, they wanted dad, the petitioner, to have 100% for mandatory additional child support and 100% for mandatory additional child support in here for reasonable uninsured health insurance. Since he was taking care of them and carrying the health insurance, he was going to be responsible 100%, since mom really just had visitation in that particular case. So that's a change there. And then the next subject I wanted to bring up was in regards to the Spousal Support 343 order. Let me see if I can pull that up. One sec here. I change the screen to 343. Okay, so here's a change to the 343. So whenever we had a default with agreement, which is the majority of our cases, you're marking the judgment form here and you mark the party stipulate. Okay, that's fine. But when we had a default without an agreement, the courts wanted us to mark the court finds. And then you'd go and fill out this form. Now they don't want you to mark any of these boxes, because not an agreement, if it's a default without an agreement. And what the court said now is the court didn't find anything. And what that means, findings, is like when you go to a trial, the court makes orders. And so that's called their findings. And so you would mark that box. So, but now they're saying they don't want that box marked. What's interesting about that is we would get these rejected because we were not marking it. And then they said they wanted it marked. So then we marked it. And now they've gone back to them not wanting it marked. So one thing of dealing with all the courts and doing this for so long is you just got to roll with the punches. Things change. Sometimes the clerks are making mistakes. They don't understand things of that nature. So, one thing I wanted to show you on that, one more change, excuse me, is on the 343, they're wanting us now to mark that this attachment relates to a judgment. So remember, this is part of your judgment. This attachment relates to a judgment for permanent spouse support or partner support. Excuse me. And then they want us to mark in how long the length of marriage in here, and then going to page 2. Geez. You don't need to fill out any of these parts here because these are again findings. And then you're going to mark the court terminates jurisdiction over the issue of spouse support for petition respondent, assuming that's the case. So what I want to talk about is I had clients ask, they said, Tim, why, we have spouse support. Give you an example. They'll say we had spouse support payable for only a year. Let's say, why are we marking on the 343 permanent spouse support? So the permanent spouse support relates to the fact that it's being attached to a final judgment. So it's not a temporary order. It's a permanent order for 1 year. You see the nuance there, and I understood the question. If it's permanent, does that mean I'm paying forever? No, it's permanent because it's part of a final order, and the agreement will be whatever the agreement was, like in this case, a year. So just a little bit play on words on there. So if you're my client or potential client, you'll know that's why we're marking permanent if there is a support order, spouse support order as part as your final judgment. Okay, next subject. I help you with the language you want to include in the settlement. You just have to let me know in plain English, and I will doctor it up for you. So folks think that the settlement agreement has to be written in a certain way, and it sort of does. They will send to me their terms for me to then include into the settlement agreement, and sometimes they will try and make it sound legalese. I know that's not a word, but they'll try and add legalese. Don't do that. If you're working with me, tell me in plain English what you want. Just explain it to me in layman's terms, however it makes sense to you and your spouse. And if the language is suitable, even if it doesn't contain legalese, then I'm going to include it because it makes sense to you. What matters is it makes sense to you. Yes, it needs to make sense to the court, but if I can understand it and it makes sense to you, it's going to make sense to the judge. We don't need the language to sound fancy. Now, sometimes I'll look at what you've given me. I had a client hire me last week, and she had a bunch of terms in there that I've never seen before. Very specific. I guess this just came to mind, but I probably should have looked up. So I don't want to bring up the specifics, but it was like he'll do certain things that were things that aren't normally included in a settlement agreement, things that are unenforceable, meaning even if they had signed the settlement agreement saying he or she will do this or that, and if they didn't do it, the court couldn't force them to do it, so it'd be unenforceable. And that's why I told her. I said, a lot of these terms you're including here are not enforceable. If he says I'm not going to work 2 jobs, I think it was something like that. Decides not to work 2 jobs, you can't enforce that he take him back to court and say, hey, he's only working 1 job, I need him to work 2. So there's a lot of things that didn't seem right in that I clarified for them that we probably wouldn't want to include. One, it just might make the other spouse upset, and another part, the court may say, you know what, let's get these folks in here. I don't know why they're having these types of terms included. Okay, so we talked about the spouse support order. Okay, next subject here. How to file for divorce without an attorney. So the reason I want to bring this up is I had a client hire me this week that, and I talked about this the other day. They called an attorney in San Fernando Valley and they quote him $10,000 for an amicable divorce. And he said, so I Googled how to file for divorce without an attorney in California. He said, Tim, I found you a YouTube video of yours you did 6 months ago. Or I'm sorry, 6 years ago. I said, gosh, that's my most recent video on how to file for divorce without an attorney. I probably should talk about that a little more and do some more videos about that, because I'm sure there's a lot of people searching for those keywords or those terms. And if they're finding a YouTube video from 6 years ago, they might think, boy, this guy's probably not still in business. But he called me, hired me, and he asked me, why do the attorneys make it so difficult? Why is it so costly? They're out here to make money. For them to take an amicable case, they don't want to charge less than $7,500, $10,000, not worth their time. They'd rather spend their time litigating and billing $500 an hour, going to court and so forth. At the end of the day, after he hired me and we talked about their terms, there's no asset debts, no kids. I'm sorry, no assets and debts, no spouse support, no child support, one child, joint legal and physical custody, as simple as you can get. And, for less than $1,600, including the court fees and your notary, versus $10,000, he was ecstatic to find our service. So if you're looking for a way to file for divorce without an attorney, you found the right guy. Okay, I'm going to talk about clients I had to fire. I'm just going to read my notes here. I recently had to fire a client due to his spouse's passive-aggressive behavior. I provide free consultations to folks to explain my service and to see if you will be a good fit for me, to see that you are both amicable, and explain that it will require you both to be cooperative and sign off on the paperwork. The gentleman I spoke to stated they were amicable, but as soon as we started the process and the wife got involved, the wife immediately became passive-aggressive. And when I asked them to upload copies of filed documents they have filed with the court so far, because they had already started their own divorce, her response was that I should be able to get those from the court, and why should she provide them to me? Right there, I knew they were not going to be a good fit for me, and I immediately refunded their money. This happens once in a while as normal. Normally, I am only speaking with one spouse, and this happens maybe 1 in 100 cases, and I'm way too busy to help people who appreciate my service, so I'm at a point in my career where I don't have to stand for that. So I told him, look, he was a very nice guy. He thought he was going to be amicable, and maybe it was, and maybe he has a different definition of that. But if you have started your own divorce and you hire me and I've talked to your spouse, and then you're going to now come into the loop, because I work with both spouses, all the cases, then you're going to be passive aggressive and hostile to me and not provide documents and just overall be a pain in the ass. I don't have to deal with that. I've been doing this 12 years. I have plenty of clients, sometimes more than I can handle. And so I fired him. I told him, look, I'm doing you a favor. I'm doing me a favor. If this is how it's going to start, and we were, an hour into it. He had just hired me, and I sent out an email to both and say, hey, can you do this? And that was the response I got. So, I'm going to just refund your money. We're doing each other a favor, because I'm not going to deal with that. I don't need to deal with people like that. And if it starts like that, it's going to be a very difficult process. And maybe it wasn't as amicable as they thought. And the reason I wanted to bring that up is I do these consultations, as I mentioned, and I'm usually only talking to one spouse, and I really hammer down on them to say, look, it needs to be amicable. You need to reach an agreement, and most of them are. And I could tell, and most of the time I'm pretty good at telling that it will, without having to talk to the other spouse. Because can you imagine if I had to talk with one, then the other? Once we loop them in, I have some onboarding emails that go out that explain what we do, some videos, and kind of onboarding. It's kind of a video consultation, if you will. They watch the video, say, okay, he's a neutral third party. He's working for both of us. The response doesn't have to be filed, et cetera, et cetera. And, but anyways, once in a while they'll slip through. We just don't know how that other party is going to respond sometimes. And what I've decided as a company policy, company of one, is I'm not going to work with you. And that's my decision. Next subject. Half our clients are still living together at the time of filing for divorce. So I bring that up because you do not have to be separated. You do not have to be legally separated. You do not have to file for legal separation prior to divorce. You don't even have to be living in separate rooms or living on the couch or anything like that. In California, totally fine to be living together at the time of filing. At least half my clients are, maybe more. Maybe more are still living together at the time of filing than are not. Talking about the date of separation, you guys are still living together. Say, Tim, we're not separated. I hear that every day. It's fine. Did you guys talk about divorce last week or last month? Yes. Okay, let's use that date. No, you haven't talked about it at all until today. Then let's use today's date. if you're reaching an agreement to division of assets and debts and so forth, and you are, like a lot of our clients are doing, each keeping their own or making decisions regardless of the date of marriage and date of separation as it relates to community property, then the date of separation isn't going to be that relevant. Now, going through attorneys, fighting for every inch and every penny, date of marriage, date of separation is the line in the sand for division of community property to include, assets, debts, vehicles you may purchase, pension contributions, and so forth. So it can make a difference. With our clients being amicable, we want to state the correct date of separation, but we've never, it's never been relevant except for when they are dividing their pensions. The date of separation will be what's used for that division. Next subject. Yeah, I love when clients, so here's my notes. I love when clients who hire me bring up things I discussed in my videos. Had a consultation today where they said in the consultation that they wanted to use my service to avoid having to file the 160 property declaration. So not to go into details on that, because I talk about that all the time, about not filing the property declarations or attaching them to your petition or attaching them to your request in or default. Not necessary if you guys are going through an amicable divorce. I talk about how to do different things, little procedural tactics to, like if you want to, don't want to include your income and expense declarations, when you don't want to have child support, or there's going to be a child support order to file the response. So that way they don't need, because people want to continue to have their privacy and not file those income statements or the property declarations. So I talk a lot about that. It's not me giving legal advice. This is procedural tactics, if you will, in processing your paperwork with the court. So hope you liked episode 63 of Divorce 661 Daily Perspective, Day in the Life of an LDA. I will try and do these daily again, second day in a row. And this is your most up-to-date and current daily podcast talking about divorce, amicable divorce in California. I hope you have a great day. We'll talk to you tomorrow.